Thank you, Chair and members. This is David Louie. I'm an attorney here in Honolulu, Hawaii. I served as the former Attorney General under Governor Abercrombie from 2011 to 2014. I have substantial experience in dealing with constitutional law issues. I've defended the state in a long-running constitutional claim. I want to thank all of you for your attention that you're paying on this important issue, and I appreciate all the concerns of you, the mayor, and everybody who's testified. I've submitted written testimony on June 6th. I have to tell you, I appreciate your concerns, but Bill 9 is problematic and violates the Constitution of the United States and the Constitution of Hawaii. These are fundamental constitutional rights that are vested rights of property owners that cannot be taken away by zoning ordinance. And that's going to be a huge problem for the county. The county wants to wipe out the Minatoya list, wants to wipe out lawful vested short-term rentals that have been going on since 1960 for decades, and you just can't do that, unfortunately. There have been 3 courts in Hawaii that have spoken on this and have ruled against what Maui County wants to do. The Hawaii Court of Appeals, Intermediate Court of Appeals, had ruled twice, once in 1997 and again in 2016, and said you can't do that. It's a matter of constitutional dimension. The U.S. District Court, the federal court in Honolulu, enjoined the ordinance in Honolulu and said it's a matter of constitutional law. The change in 46-4 of the Hawaii Revised Statutes does not change this because we're talking about fundamental constitutional rights. This is an unconstitutional taking that results in damage and will create gigantic potential liabilities for the county of Maui in tens of millions, perhaps more. And I mean, UHERO itself predicts that condo prices will decline 20 to 40%, and that will be on the county as a liability for taking, because the Hawaii Constitution says taking or damage. And so that's going to be hugely problematic. Therefore, because of these severe consequences to the budget, to the taxes, to the liabilities of the county, I recommend that this bill is premature until the county can figure out how it's going to handle the compensation issues and deal with all of the economic losses. And therefore, we urge you, I speak on behalf of Airbnb, my client, but I am telling you as a constitutional lawyer, this is gigantically problematic, and I request that you hold the bill.
Thank you, Mr. Louie. Member Chair Lee has a question for you.
Yes.
So does Member Rollins-Fernandez.
Hello, Mr. Louie. Could you tell us which 3 cases went before the appeals court? Or you said 2 cases before the appeals court and then another one. Were those cases related to short-term rentals?
The first case before the
2 cases before the appeals court and then another one. Were those cases related to short-term? 3 cases went before the appeals court? Or you said 2 cases before the appeals court and then another one. Were those cases related to short-term rentals?
The first case before the Intermediate Court of Appeals in 1997 was the Waikiki Marketplace case. It was not related to short-term rentals. However, in 2016, the Hawaii Intermediate Court of Appeals affirmed the ruling, said that there were serious constitutional questions, and held that in the context of short-term rentals, there are vested rights of property owners. That's a 2016 case. I'll give you a citation in just 1 minute. That's the Ferris Trust case. Look at 138 Hawaii 313.
Okay, and the third
finally,
case? Yeah.
The third case is the United States District Court case, which ruled in Hawaii Legal Short-Term Rental Alliance versus City and County of Honolulu. I have to give you this Westlaw site, which is 2022 WL 7471692. That's a 2022 case, and that was Judge Derek Watson, who granted a preliminary injunction and then later a permanent injunction against the enforcement of the Honolulu ordinance that was restricting short-term rentals.
Okay, thank you.
So those are the three cases in Hawaii. I mean, and two of them are short-term rental cases.
Thank you.
Thank you, Chair. Member Rollins Fernandez?
Mahalo, Chair. Aloha, Mr. Louie. Mahalo for your testimony. Did you disclose that you're a lobbyist for Airbnb?
I mentioned that at the end of my testimony, that I represent Airbnb. Yes.
Okay. So we will, I'm sure, hear about the cases that you cited from our own attorneys and not from Airbnb's attorney. And then for that last case, the Honolulu case, a big part of that injunction was because it was a 6-month phase out, correct?
I'm sorry, say that again?
The change in the definition was 6 months.
So what happened?
I mean, we won't have to discuss it. We'll go in
Yeah.
deeper detail with our own attorneys in executive session, but appreciate your comments.
I appreciate that. Let me just respond. If your attorneys are telling you you can get around the Constitution, I seriously disagree. You obviously have legal advice from your attorneys. I've worked with your attorneys both with them and against them. But I seriously disagree if they're saying that you can walk away from this
Thank you, Mr.
with
Louie.
no
for that.
damage.
Members, any other questions
Mahalo,
for the
Chair.
testifier? Seeing none. Thank you so much, Mr. Louie.